I am Syed Almas Hussain Shah, advocate. Welcome to enter the exciting world of cross-examination. Truth, falsehood, anger, scorn, despair. All the passions, all the souls is there. Cross-examination is a distinctive and the vital feature of English law. Testimony of the witness has no legal evidence unless it is subjected to cross-examination. Cross-examination, practicing, mastering the steps which are helpful and increase your chances of success, giving you confidence of the court and the client. Cross-examination is questioning adversary witnesses and is a potent weapon of probing the credibility and reliability of the adversary version of the event. A successful cross-examination is the highest attainment of an advocate's art. It is difficult to frame any rules covering it. The technique can be acquired by the natural instinct or by the practice. What follow are not the rules but the guidelines. Range of cross-examination is unlimited, only condition being that it is related to relative facts. Remember that the cross-examination is also a double-edged weapon. If you enter into an unknown area or unprepared proposition, it may sometimes wound you. Avoid the cross-examination if the witness does your case no harm. Preparation for cross-examination entails 3 basic steps. Developing a case theory. Once you have defined your case theory, that is what you aim at. Your next step is to create the evidential support. You will recall the phrase examine wagon to wagon of the train. For the purpose of cross-examination, it means the series of cluster and goal-oriented questions, each cluster designed to establish one practice point, the fitting into the case theory. Be careful not to select such area of witness story which is harmful to your case. One fact per question means that your cross-examination is cleaner and you can avoid the question by writing to clarify. Aim through your cross-examination is to defend your case, weaken the evidence, undermine the credibility of the witness, and be cautious not to question a witness too much. If you come to conclusion he is truthful in a criminal case, if you cannot break a witness down, try to attack his reliability. If you can undermine a witness, you can bring the case within the parameter or probability which may get you the benefit of doubt. You have studied and analyzed the statement or the witnesses made by him to investigating police officer under the 161 Criminal Procedure Code statement. You can notice the area where the witness under the cross-examination has contradicted his own evidence given to the examiner-in-chief. The version of prosecution is general. This should be a create the source. You could be able to contradict the witness as well as the prosecution story. Whereas in the cases in examiner-in-chief, the recommendation is to proceed chronologically, but cross-examining the caution is to do not proceed chronologically because the witness will be more prepared in this regard. And stop when to get what you want. Do not ask the fatal final question. If you know the answer you had planned in the advance and you have got them from the witness on record, stop asking any further questions and avoid the theory of fishing. Above a principle is supplement this theory not to go fishing. If you go fishing, you have to end up with anything you catch up. And lastly, finally, no one correct method of cross-examination can be suggested. You have to use the different techniques and the style with the different witnesses. Of course, the nature and the type of witness and the content of his evidence may be good guide. However, choose the technique that suits your style the best. This does not mean that you will be a good examiner only after you have achieved the competency in many trials. I do not believe the need to be true. The trial work is general and cross-examination in particular can be acquired even in the earlier stages. It is not the monopoly of the seniors, nor would I recommend that you have to read dozens of trial related books All that you need is to know the few suggestions made above and alter while the other side is examining.